The Willow Creek Estates sign gleamed in the morning sunlight as we drove through the neighborhood for the first time. Perfect rows of identical two-story homes lined streets with names like Harmony Lane and Tranquility Court. Catherine and I had searched for months to find the right place to settle down. A neighborhood with good schools for our future children, reasonable commuting distance to the courthouse where she served as a district judge, and most importantly, a sense of community. "This is it," Catherine said, squeezing my hand as we pulled into the driveway of 437 Serenity Drive. The real estate agent had emphasized how the immaculate appearance of the neighborhood was maintained by an active homeowners association with strict standards. At the time, we considered this a positive feature. Structure meant security. Standards meant property values would remain stable. We had no idea what nightmares lay beneath that perfectly manicured surface. The first 3 months were everything we had hoped for. We painted rooms, arranged furniture, and planted flowers in the small garden plot allowed by HOA regulations. Our neighbors seemed friendly if somewhat reserved. We noticed peculiar things occasionally: how quickly recycling bins disappeared from curbs after collection, how everyone's blinds were uniformly positioned, how lawn ornaments never appeared in any yard. But these seemed like minor quirks rather than warning signs. Then Catherine needed surgery. A torn meniscus from an old running injury had finally deteriorated to the point where repair was necessary. The procedure was routine, but would require 6 to 8 weeks of recovery with limited mobility. I took time off work to help her during the initial recovery period. The doctor prescribed crutches to keep weight off her knee while the surgical site healed. Catherine hated feeling dependent. "I will be back to work in 3 weeks," she insisted as I helped her from the car after the surgery. The crutches clicked against our concrete driveway as she awkwardly navigated her way toward our front door. I noticed curtains twitching in the house across the street. Mrs. Peterson, watching as always, but I was too focused on helping Catherine to care about nosy neighbors. Our troubles began the day I decided to install a temporary wooden ramp over the 3 steps leading to our front porch. The incline was gentle, making it easier for Catherine to enter and exit the house without navigating steps with her crutches. I constructed it carefully, using pressure-treated lumber, ensuring it was sturdy and safe. I even painted it to match our house trim, trying to maintain the aesthetic harmony of the neighborhood. The knock came at 7:30 that evening. Sharp, aggressive raps that seemed unnecessarily loud. I opened the door to find a slender woman with artificially blonde hair pulled into a tight ponytail. She wore pressed khaki pants and a polo shirt with the HOA logo embroidered on the breast pocket. Her lips were pressed into a thin line as she held up a digital camera, reviewing photos she had apparently just taken of our front entrance. "Good evening," I said, attempting politeness despite her scowl. "Can I help you?" "I am Deborah Winters, president of the Willow Creek Estates Homeowners Association," she replied without looking up from her camera. "You have installed an unauthorized structural modification to your property. Section 8, Paragraph 4 of the covenant clearly states that all exterior modifications require prior board approval." Before I could explain, her camera flashed, capturing another image of the ramp. "This will need to be removed immediately. You will also receive a notice of violation and associated fine in tomorrow's mail." Only then did she actually look at me, her expression suggesting she was dealing with a deliberate criminal rather than a resident trying to help his injured wife. Catherine called from the living room. "Who is it, Michael?" "HOA representative," I replied over my shoulder, then turned back to Deborah. "My wife just had knee surgery. This is a temporary accommodation until she can safely navigate the steps." Deborah's eyes narrowed. Medical necessities still require proper approval channels. The appearance of the neighborhood affects everyone's property values. She handed me a business card. You can submit a formal request for accommodation at our next monthly meeting. Until then, this structure needs to be removed within 48 hours to avoid additional penalties. As she turned to leave, Catherine appeared behind me, balancing precariously on her crutches. "Is there a problem?" she asked. Deborah gave Catherine a quick assessment, her eyes lingering on the crutches with visible distaste. "Just a minor covenant violation that needs addressing. Nothing for you to worry about." Her tone had suddenly shifted to sugary sweetness. "Focus on your recovery. We just need your husband to follow proper procedures." As she walked away, I noticed her stopping to take photos of other houses along our street. Catherine and I exchanged concerned glances. That night, we reviewed the massive 3-ring binder of HOA regulations we had received but barely skimmed when purchasing the house. Buried in the excessive documentation were requirements for everything from acceptable mailbox designs to approved shades of white for window trim. Our peaceful beginning in Willow Creek Estates had been shattered by the sharp knock of an HOA president's knuckles against our door. The violation notice arrived the next morning as promised, a bright yellow envelope containing a form with clinical precision documenting our infraction. The fine was $150, with additional daily penalties of $75 if the violation was not corrected within the 48-hour window. I stared at the paper in disbelief. The amount was not devastating, but the principle was infuriating. Catherine was in pain and needed this accommodation. I called the number printed on the HOA letterhead. After 3 transfers and 15 minutes on hold, I finally reached Deborah. "I understand your concern about neighborhood aesthetics," I said, keeping my tone reasonable and calm. "But this is a temporary medical accommodation. The Americans with Disabilities Act provides protections for." "This is not a public accommodation," Deborah interrupted. "This is a private community with covenants you agreed to when purchasing your property. The ADA does not supersede our legally binding agreements." "Could we request an emergency exception? My wife cannot safely." "Submit the proper forms for the next meeting. The board will consider your request then." "When is the next meeting?" I asked. 3 weeks from Thursday," she replied with what sounded like satisfaction. "Until then, you need to remove the unauthorized structure." I hung up, frustration building in my chest. Catherine was resting upstairs, and I did not want to burden her with this ridiculousness during her recovery. She had enough challenges without adding HOA politics to her concerns. I decided to seek another solution before involving her further. That afternoon, I walked through the neighborhood, hoping to speak with other residents about their experiences with the HOA. Most people seemed reluctant to talk openly, offering polite but brief exchanges before retreating into their homes. But as I turned onto Harmony Lane, I noticed an elderly man working in his garden. His yard stood out subtly, not enough to be obviously different, but with small touches of personality absent from other properties. "Good-looking tomatoes," I commented, pausing by his fence. He straightened slowly, one hand pressing against his lower back. "Thanks, Jacob Thompson," he said, extending a soil-covered hand which I shook without hesitation. "Michael Mitchell. We moved in on Serenity Drive a few months ago." Something in his expression changed. "Ah, the new folks with the temporary ramp. Word travels fast around here." I nodded, surprised but relieved to find someone willing to discuss the situation. Jacob glanced around before gesturing me closer. "Listen, you are not the first to run into problems with Deborah. She has been making life difficult for everyone since taking over the board 2 years ago. Used to be reasonable people running things. Now it is all about control and generating revenue through fines. Over the next 30 minutes, Jacob shared stories that chilled me. An elderly couple forced to remove a handrail they needed for stability. A family fined repeatedly because their child's wheelchair left marks on the driveway. A veteran prohibited from flying an American flag because the pole exceeded height restrictions by 2 inches. "Why does everyone tolerate this?" I asked. Jacob sighed. "Most people just want a quiet life. Pay the fines, follow the rules, avoid conflict. Those who fight eventually get worn down or move out. Deborah knows exactly how far she can push without crossing into legally actionable territory." I returned home with a heavier heart but more determined than ever. Catherine noticed my mood immediately. "What is wrong?" she asked as I helped her adjust her position on the couch. "Nothing important," I lied, not wanting to burden her. "Just thinking about work." That night, I dismantled the ramp, replacing it with a less obvious solution, a series of textured rubber mats creating a gentler transition between levels. It was not ideal, but perhaps less likely to attract HOA attention. I submitted the formal accommodation request form for the upcoming meeting, complete with doctor's notes and relevant medical documentation. The next morning, another yellow envelope awaited us. "Unauthorized ground covering on shared visual space," the violation read. "Another $150 fine." This time, I could not hide my frustration. Catherine found me at the kitchen table, staring at the growing collection of notices. "Michael, what is going on?" she asked, her voice firm and judicial, the tone she likely used in her courtroom. I reluctantly shared everything: the violations, the conversation with Jacob, the apparent pattern of discrimination against residents with disabilities or special needs. Catherine listened intently, her expression darkening. "This is unacceptable," she said finally. "These practices potentially violate multiple housing laws. We need to document everything." But before we could implement any real strategy, the situation escalated dramatically. The next morning, a certified letter arrived containing notice that our property was now subject to daily inspections due to repeated violations demonstrating disregard for community standards. Every minor imperfection became grounds for additional fines. A garden hose not properly stored, blinds closed at non-regulation hours, Catherine's crutches visible through the front window. 2 weeks after my conversation with Jacob, the HOA held its monthly meeting at the community clubhouse. Catherine insisted on attending despite her limited mobility. The room fell silent as we entered, Catherine moving slowly with her crutches. Deborah sat at the center of a long table, flanked by 4 other board members who seemed to function primarily as an audience for her proclamations. The discussion of our accommodation request came last on the agenda, after 2 hours of mind-numbing procedural minutiae. When our item finally came up, Deborah spoke as if we were not even present. "The board has reviewed the Mitchell request for a front entrance modification. While we sympathize with temporary medical conditions, allowing visible accessibility equipment would set a concerning precedent for neighborhood aesthetics." "Precedent?" I interrupted, unable to contain myself. "We are talking about basic accessibility for someone recovering from surgery." Deborah's eyes narrowed. "If you cannot follow established procedures, perhaps this neighborhood is not the right fit for your situation." She turned to Catherine. "Perhaps your condition requires residential features our community simply cannot accommodate while maintaining standards." The implication was clear: if you need accessibility accommodations, you do not belong here. Catherine's face flushed with anger and humiliation. Despite her professional success and respected position as a judge, She was being treated as if her temporary disability made her unwelcome in her own neighborhood. "The request is denied," Deborah announced with finality. "Furthermore, an additional fine is being assessed for argumentative behavior during official proceedings." As murmurs rippled through the room, I helped Catherine to her feet, our relationship with the HOA now openly hostile. The morning that changed everything began normally enough. I had an unavoidable meeting with clients that Catherine had insisted I attend despite my reluctance to leave her alone. "I am perfectly capable of managing a few hours by myself," she had assured me, demonstrating how she had arranged everything she might need within easy reach. "Call me if you need anything at all," I said, kissing her goodbye. "I will be back by early afternoon." The meeting ran long, as important meetings often do. When I checked my phone during a brief break, I had no messages from Catherine, which I took as a good sign. How wrong I was. At home, Catherine had been managing reasonably well. She had worked remotely from her laptop, reviewing case files while elevating her leg as the doctor recommended. Around noon, the doorbell rang, an unexpected and unwelcome intrusion on her carefully managed routine. Using her crutches, she made her slow, deliberate way to the door, checking through the peephole before opening it. Deborah Winters stood on the porch, accompanied by two other HOA board members, a thin man with a permanent squint and a heavy-set woman clutching a tablet. Catherine later told me how her heart had sunk at the sight of them, but she had maintained her composure, opening the door while balancing on her crutches. "Good afternoon," she greeted them with professional courtesy despite their past interactions. Deborah did not return the pleasantry. "We are conducting an inspection following multiple violation reports," she announced, already pushing past Catherine into the foyer. "Your husband has been uncooperative with compliance efforts." "This is not a good time," Catherine replied firmly. "My husband will be back later if you need to discuss any concerns." The trio ignored her, moving further into our home without permission. The woman with the tablet began photographing our living room where Catherine's medical supplies, prescription bottles, ice pack therapy equipment, were arranged for accessibility. "These items are visible from the street through your front windows," Deborah stated, pointing to Catherine's crutches which were propped against the sofa. Section 12, Paragraph 7 prohibits storage of equipment, medical or otherwise, in visually accessible areas. Catherine stood her ground. "Those are not stored items. They are actively used medical necessities." "They affect the visual consistency of the neighborhood," Deborah countered. Her eyes narrowed as she reached for the crutches. "These will need to be relocated to a non-visible area of the home." "Do not touch those," Catherine warned, her judicial authority evident in her tone. "I need them to move safely." But Deborah had already grasped the crutches, pulling them away. "Medical equipment must be properly stored between uses. We will hold these until you can make appropriate arrangements that comply with regulations." Catherine reached out instinctively, trying to reclaim her mobility aids. The sudden movement threw her off balance. Without the crutches for support, she fell awkwardly, her recently operated knee twisting as she collapsed onto the hardwood floor. Her cry of pain did not seem to register with Deborah, who was already heading toward the door, crutches in hand. "Your husband can collect these at the HOA office after submitting the proper storage compliance forms." "I cannot move without those," Catherine protested through gritted teeth, pain radiating from her knee. "That is not an HOA concern," Deborah replied coldly. "Perhaps this will motivate proper compliance moving forward." The trio departed, pulling our front door closed behind them, leaving Catherine stranded on the floor with no way to stand or reach her phone. For over an hour, she dragged herself painfully across the floor, trying to reach her cell phone on the kitchen counter. By the time I returned home, she was exhausted, in severe pain, and rightfully furious. I found her on the kitchen floor, her surgical leg awkwardly extended, tear tracks dried on her face. "Catherine," I rushed to her side, panic and confusion overwhelming me. "What happened? Where are your crutches?" Through pained breaths, she explained the unimaginable, how Deborah had actually taken her mobility aids, leaving her helpless in our own home. As I helped her onto a chair and examined her knee, now swollen and bruised from the fall, rage built inside me like nothing I had ever experienced before. "We need to get you to the hospital," I said, trying to keep my voice steady. "Then I am going to the police to report this." As I gathered our things, preparing to help Catherine to the car, a soft knock came at our back door. I opened it cautiously to find our next-door neighbor, Lisa Garcia, looking nervously over her shoulder. "I saw what happened," she whispered, holding up her phone. "My security camera caught everything, them entering your house, taking the crutches, your wife falling. I have it all recorded." She glanced around again, paranoid about being seen talking to us. "What that woman did, it is not right. Many of us are tired of living under her tyranny, but we have been too afraid to stand up to her." I thanked Lisa, taking her contact information before helping Catherine to the car. At the hospital, the doctor confirmed our fears. Catherine's fall had damaged her surgical repair, requiring additional procedures and extending her recovery by several months. As we sat in the sterile examination room, waiting for the orthopedic specialist, Catherine took my hand. "This has gone far beyond HOA overreach," she said, her voice calm despite her pain. "This is criminal behavior and possible assault, but we need to be strategic about how we respond." Despite my desire for immediate justice, to confront Deborah, to call the police, to file charges that instant, I knew Catherine was right. Her judicial mind was already working through the optimal approach, even through her physical discomfort. We needed to be smarter than our opponent, more patient, more thorough. This was no longer just about neighborhood politics. It was about fundamental rights, safety in our own home, and holding accountable those who abused their power. As we left the hospital that evening, Catherine now with hospital-issued crutches and additional pain medication, we made a pact. This would not stand. Justice would come, but on our terms, through proper channels with irrefutable evidence. Little did Deborah know she had not just crossed a line, she had declared war on the wrong family. The dining room table disappeared under stacks of papers, binders, and legal documents. Catherine, despite her increased pain and extended recovery timeline, approached our situation with the methodical precision that had earned her respect in the courtroom. I marveled at her transformation from injured victim to strategic commander, her professional training now focused entirely on our personal battle. "We need to be comprehensive and meticulous," she instructed as we organized our materials. "Emotional reactions might feel satisfying in the moment, but preparation and documentation win cases." First, we gathered evidence of everything that had transpired since we moved in, every violation notice, every email, every interaction. Catherine created a detailed chronology, highlighting the escalating pattern of harassment. I reached out to Jacob Thompson and other neighbors who had shared stories of similar treatment, asking them to provide written statements about their experiences. Lisa Garcia's security footage became our most damning evidence. The video clearly showed Deborah and her associates entering our home, confiscating Catherine's crutches despite her protests, and leaving her incapacitated on the floor. The footage included audio, capturing Deborah's callous comments as Catherine fell. This is not just HOA overreach, Catherine said as we reviewed the footage for the 20th time. This is breaking and entering, theft, and possibly assault. But before we go to the police, I want to understand the bigger picture. Catherine assigned me the task of researching Willow Creek Estate's HOA's legal history, while she focused on identifying relevant housing laws and accessibility regulations that had potentially been violated. Working remotely from her laptop, she accessed legal databases and precedent cases involving homeowners associations and disability accommodations. 3 days into our investigation, Catherine made a significant discovery. "Michael, look at this," she called from her makeshift office on the couch. She turned her laptop screen toward me, showing a court docket from the county system. The HOA has filed a lawsuit against 7 homeowners in our neighborhood for various covenant violations. The case has been in process for nearly 6 months. I leaned closer, scanning the document. What are they seeking? Substantial financial penalties, forced compliance, even potential property liens. Catherine scrolled through the filing. But here is what is interesting based on the case number and district assignment. This will almost certainly come to my courtroom when it reaches the hearing phase next month. Our eyes met as the implications became clear. Deborah had no idea that the judge who would hear the HOA's lawsuit was the same woman whose crutches she had stolen, the same woman she had left injured on her own floor. "Should you recuse yourself?" I asked, though part of me hoped she would not. Catherine considered this carefully. "Initially, yes. I will need to disclose the personal conflict, but the recusal might only be temporary depending on how events unfold." A slight smile played at the corners of her mouth, not vindictive but determined. "The law provides specific guidelines for these situations. We will follow them precisely." As Catherine's legal strategy took shape, I focused on community organizing. Lisa Garcia introduced me to other residents who had suffered under Deborah's reign. We met secretly in finished basements and back patios, sharing stories and building a coalition. Many had documented their own experiences, violation notices for trivial infractions, denied requests for reasonable accommodations, aggressive enforcement actions. Eric Donovan, a retired civil rights attorney living on Tranquility Court, offered his expertise. "What you are describing goes beyond HOA enforcement," he explained during one of our clandestine meetings. "These practices potentially violate the Fair Housing Act, particularly regarding reasonable accommodations for disabilities." Together, we compiled a comprehensive history of discriminatory practices by the current HOA leadership. Elderly residents forced to remove safety modifications. A family with an autistic child fined for having therapeutic equipment visible in their yard. A veteran prohibited from installing a wheelchair ramp without going through months of aesthetic review. Meanwhile, Catherine discovered a pattern of selective enforcement. Certain board members and their friends received exemptions from rules that were strictly enforced against others. Financial records showed suspicious patterns in how violation fees were allocated and spent. 2 weeks after the incident, we convened our growing coalition at Eric's home. Over 20 households were represented, each with their own stories of HOA abuse. Catherine attended virtually, still limited by her injuries but determined to be involved. "What we need now is coordination," she explained to the group. "When the HOA's current lawsuit proceeds to court, it will expose their practices to legal scrutiny. But we need everyone's participation to demonstrate this is not an isolated incident but a systematic problem." The energy in the room was palpable. People who had felt powerless individually now recognizing their collective strength. We established secure communication channels, assigned documentation responsibilities, and prepared for the legal process ahead. That night, as Catherine and I reviewed our progress, she made a critical observation. "We have not filed a police report about the Crutches incident," she noted. "Strategically, I think we should wait." "Why?" I asked, surprised by her restraint. "Right now, Deborah believes she intimidated us into submission. That perceived victory will make her careless." Catherine's eyes gleamed with the strategic thinking that had made her formidable in the courtroom. "Let her continue operating as usual while we build our case. When the time comes, the contrast between her behavior and our methodical response will be stark." I trusted Catherine's judgment, though restraining my anger remained difficult. Every time I helped her navigate our home with her new crutches, every wince of pain as she adjusted her position, every additional medication she required fueled my determination to see justice served. Our dining room had transformed into a war room, our scattered papers now organized into comprehensive files. The centerpiece was a laptop continuously playing Lisa's security footage, the damning evidence of Deborah crossing the line from bureaucratic harassment to criminal behavior. As we strategized late into the night, Catherine and I were no longer just homeowners fighting an unreasonable HOA. We were architects of justice, methodically building a case that would not only resolve our situation but potentially protect our entire community. "They have no idea what is coming," I said as I helped Catherine to bed that night. She smiled, squeezing my hand. "No, they do not, and that is exactly how we want it." The certified letters arrived on a Tuesday morning, identical legal envelopes delivered to 7 households throughout Willow Creek Estates, including ours. The HOA was officially proceeding with their lawsuit against residents they deemed in persistent violation of community covenants. The document listed our alleged infractions in clinical legal language, demanding compliance and seeking significant financial penalties. Most recipients reacted with dread and anxiety. For us, it was the trigger we had been waiting for. That evening, our coalition gathered in Eric Donovan's basement to review the lawsuit details. "They are overreaching," Eric explained, pointing to specific sections of the filing. "Several of these demands violate state housing protections, but they are counting on residents being too intimidated to fight back properly." Meanwhile, across the neighborhood at the community clubhouse, the HOA board held an emergency meeting. Through our growing network of allies, we learned what transpired. Deborah stood triumphantly before her fellow board members and their attorney, a slick corporate lawyer named Richardson from a prestigious firm downtown. "The lawsuits have been filed," she announced with evident satisfaction. "Once we establish precedent with these cases, enforcement will become much simpler. No more arguments, no more excuses, just compliance or consequences." "Which judge will hear the case?" one board member asked. "Judge Mitchell in District 3, Richardson replied, reviewing his notes. "She has a reputation for being fair but strict about contractual obligations. The covenant agreements are legally binding, and she typically respects that. We have a strong position." Deborah smiled, oblivious to the irony of her confidence. "Excellent. I am tired of troublemakers thinking they can ignore our regulations without consequences." The following day, the court formally assigned the consolidated HOA lawsuit to Catherine's docket. As planned, she immediately filed a recusal notice citing personal involvement with the parties to the case. This temporary step was procedurally necessary and strategically vital. Judge Samuel Wilson was assigned as her replacement, a meticulous, by-the-book jurist nearing retirement. He scheduled an initial hearing for the following week to address preliminary motions. At the first hearing, Richardson presented the HOA's case with practiced confidence. Your Honor, this is a straightforward matter of contract enforcement. When purchasing property in Willow Creek Estates, all defendants signed binding agreements to comply with community covenants. Their persistent violations undermine neighborhood standards and property values. Judge Wilson listened impassively, occasionally making notes. When Richardson finished, our coalition's legal representative, Eric Donovan, now officially representing several defendants including us, stood to respond. Your Honor, this case extends far beyond simple covenant enforcement, Eric began. We have documented evidence of discriminatory practices, selective enforcement, and actions that potentially violate federal housing protections, particularly regarding disability accommodations. Eric submitted our carefully compiled documentation, statements from affected residents, photographic evidence, financial records showing inconsistent application of rules. Most importantly, he included a sealed exhibit marked medical emergency resulting from HOA action, Lisa's security footage and Catherine's medical records from the Crutches incident. Judge Wilson, initially appearing disinterested, became visibly concerned as he reviewed the materials. Mr. Richardson, these allegations are serious. Did the HOA board consider potential ADA implications when denying accessibility accommodations? Richardson appeared momentarily flustered. Your Honor, private community covenants operate under different standards than public accommodations. That is an oversimplification of the law, Judge Wilson replied sharply. The Fair Housing Act still applies to HOAs, particularly regarding reasonable accommodations for disabilities. He continued reviewing the documents, his expression darkening. I am particularly troubled by this sealed exhibit. Mr. Richardson, has your client explained these actions to you? Richardson requested a brief recess to consult with his clients. When court resumed 30 minutes later, his previously confident demeanor had visibly deflated. Your Honor, my clients were not completely forthcoming about certain enforcement actions. We request additional time to review these materials and perhaps discuss settlement options. Judge Wilson denied the request. This court takes allegations of disability discrimination extremely seriously. I am ordering discovery to proceed immediately, with specific attention to HOA accommodation practices and enforcement patterns. We will reconvene in 2 weeks. As we left the courthouse, Eric could barely contain his satisfaction. Did you see Richardson's face when the judge mentioned the sealed exhibit? He had no idea what his client has been doing. The following days brought exactly what we had anticipated: panic within the HOA leadership. Richardson requested an emergency meeting with the board to discuss the case's unexpected developments. Our sources reported that he arrived looking grim, carrying our evidence files. Why was I not informed about this? He demanded, playing the security footage showing Deborah taking Catherine's crutches. Do you understand the legal liability you have created? This goes beyond HOA enforcement into potential criminal territory. Deborah appeared genuinely shocked that her actions had been recorded. She was violating clear regulations about medical equipment visibility. I was simply enforcing. You entered a private residence and removed necessary medical equipment from a disabled individual, causing injury, Richardson interrupted. No court in this country will side with you on this. We need to discuss settlement immediately. But Deborah remained defiant. We cannot show weakness. If we back down, everyone will start ignoring the covenants. Besides, it is just one incident against years of proper enforcement. Richardson shook his head in disbelief. It is one incident that was caught on video. The judge has already indicated serious concerns about your practices, and these financial records showing selective enforcement. He flipped through more documents. This is indefensible. He pulled out his phone, dialing rapidly. I need to speak with Judge Wilson's clerk immediately about expediting a settlement conference. Deborah snatched the phone from his hand. No settlements. We proceed as planned. Find a different strategy. Richardson stared at her incredulously. There is no different strategy. You have created a legal nightmare. As your counsel, I strongly advise. We pay your firm a substantial retainer to win cases, not surrender at the first challenge, Deborah snapped. If you cannot do that, perhaps we need different representation. This confrontation led to an unexpected development. The following morning, Richardson's law firm filed a motion to withdraw as counsel for the HOA, citing irreconcilable differences regarding case strategy. Judge Wilson granted the motion, giving the HOA 10 days to secure new representation. In a desperate move, Deborah hired Ethan Parker, a less experienced but more aggressive attorney known for controversial tactics. Parker immediately filed motions to expedite proceedings and return the case to the regular judicial assignment rotation, effectively requesting Catherine's return to the case. They have no idea what they are asking for, Eric chuckled when he called to inform us of this development. They think they are maneuvering for a fresh start, but they are walking right into our trap. Judge Wilson, frustrated by the delays and concerned about the evidence he had reviewed, granted the motion to return the case to regular rotation. With no other judges available in the overwhelmed district, the case was reassigned to Catherine, who was now legally permitted to return after the initial recusal period. The stage was set. Deborah, still unaware of Catherine's identity, had inadvertently requested that her case be heard by the very woman whose crutches she had stolen, a judge who had witnessed firsthand the HOA's discriminatory practices and abuse of power. As Catherine reviewed the case file that evening, now officially as the presiding judge rather than an interested party, she maintained absolute professionalism. The law will speak for itself, she said, carefully separating her personal experience from her judicial responsibilities. All I need to do is apply it correctly. The final hearing was scheduled. Notices were sent, and somewhere in Willow Creek Estates, an HOA president remained blissfully unaware that she had engineered her own downfall. The courtroom hummed with tension as residents of Willow Creek Estates filled the public seating area. On one side sat Deborah and the HOA board members, dressed in business attire projecting confidence they likely did not feel. Their new attorney, Ethan Parker, arranged papers with aggressive efficiency, occasionally whispering reassurances to his clients. On the other side sat the defendant homeowners, myself included, alongside Eric and our coalition supporters. We maintained composed expressions despite the anticipation building inside us all. After months of preparation, documentation, and strategic patience, this moment had finally arrived. Court officers prepared the room. The bailiff checked his watch and moved to his position. "All rise," he called out in a commanding voice. "The Superior Court of the 3rd District is now in session, the Honorable Judge Catherine Mitchell presiding." The door to the judge's chambers opened. Catherine entered, walking with measured steps and the assistance of a sleek black cane, a permanent necessity following the complications from her fall. Her judicial robes concealed most evidence of her previous injuries, but the cane and slight limp remained unavoidable reminders. I watched Deborah's face as Catherine approached the bench. For several seconds, There was only confusion as she tried to place where she had seen this judge before. Then came the dawning horror of recognition. The blood drained from her face so dramatically that for a moment I thought she might faint. She clutched Parker's arm, whispering urgently. Parker looked confused, then dismissive as he shook off her hand. He clearly believed his client was experiencing simple court anxiety rather than the devastating realization that was actually unfolding. Catherine took her seat at the bench, arranging her materials with professional detachment. If she noticed Deborah's reaction, she gave no indication. "Good morning," she addressed the court. "We are here in the matter of Willow Creek Estates Homeowners Association versus Thompson et al. Is counsel ready to proceed?" Eric stood first, ready for the defendants, Your Honor. Parker rose next, visibly distracted by his client's increasingly frantic whispers. "Ethan Parker for the plaintiff, Your Honor. Before we begin, my client has just raised a concern that I need to address. May we request a brief recess?" Catherine regarded him impassively. "We have just convened, counselor. What concern requires immediate attention?" Parker glanced at Deborah, whose complexion had now transitioned from pale shock to flushed panic. "My client believes there may be a conflict of interest, Your Honor." "Indeed," Catherine's expression remained neutral. "Please elaborate." Deborah leaned forward, whispering more urgently to Parker, who looked increasingly uncomfortable as he began to understand the situation. "Your Honor," Parker said carefully, "my client indicates she may have had previous interactions with you outside of court that could potentially. If your client is referring to an incident at my residence approximately 4 months ago involving unauthorized entry and removal of medical equipment, resulting in personal injury," Catherine interrupted with clinical precision, "that matter has been properly documented in court records and was addressed during the initial recusal period." A murmur rippled through the courtroom as spectators understood the implications. Parker's expression shifted from confusion to alarm as he finally grasped the full situation. "Your Honor, given these circumstances, we would respectfully request your recusal from this case," Parker managed, now fully aware of the precarious position his client had created. Catherine consulted her papers before responding. "That request was available during the initial assignment period. Your predecessor counsel was informed of my temporary recusal and its reason. However, it was your motion, Mr. Parker, filed last week, that specifically requested return to regular judicial rotation, effectively waiving conflict concerns." She looked directly at him. "The court record shows you were provided complete documentation regarding the previous temporary recusal and its basis. Did you not review these materials?" Parker's discomfort was palpable. "I may not have examined all background documents thoroughly, Your Honor." "I see." Catherine's tone was measured. "Nevertheless, judicial ethics require that I address this directly. Yes, I have personal knowledge of HOA enforcement actions as a resident. However, this does not automatically disqualify me if I can rule impartially on the legal questions before the court." She looked at both attorneys. "I will consider any legitimate legal arguments regarding my qualification to hear this case. Does either counsel wish to make such arguments for the record?" Eric stood. "The defendants have no objection to Your Honor presiding, having full confidence in the court's ability to rule on legal merits rather than personal considerations." Parker conferred briefly with his now visibly distressed client. "Your Honor, we withdraw our concern and are prepared to proceed." "Very well," Catherine nodded. "Opening statements then. Mr. Parker, as plaintiff's counsel, you may begin." Parker gathered himself, attempting to recover professional composure despite the catastrophic realization that his client had personally wronged the judge now hearing their case. His opening statement lacked the aggressive confidence he was known for, instead focusing on technical covenant language while carefully avoiding any mention of enforcement methods. When Eric's turn came, his presentation was methodical and devastating. He outlined a pattern of discriminatory practices, selective enforcement, and harassment, all documented with meticulous evidence. Most powerfully, he described how these actions affected real people: elderly residents unable to safely access their homes, families with special needs, children faced with impossible compliance demands, and yes, a resident recovering from surgery who had her medical equipment confiscated, resulting in additional injury. Throughout the proceedings, Catherine maintained absolute judicial propriety. She asked clarifying questions of both sides, occasionally ruling on technical objections, and giving no indication that she had any personal stake in the outcome. If anything, she seemed to hold Eric to a higher standard of proof, requiring specific legal bases for each claim against the HOA. During witness testimony, several residents described their experiences with HOA enforcement. Jacob Thompson explained how he had been fined for installing a safety rail after his wife's stroke. Lisa Garcia testified about the security footage capturing the incident at our home, which was played in court. The video evidence created an audible reaction from spectators as they watched Deborah removing Catherine's crutches and leaving her immobilized. When my turn came to testify, I described our experiences factually, without emotional embellishment. Catherine treated me exactly as she had other witnesses, interrupting once to remind me to stick to relevant facts when my testimony strayed toward characterizing Deborah's motivations. The most revealing moment came during Deborah's testimony. Under Parker's careful questioning, she attempted to justify HOA actions as necessary for maintaining community standards and property values. But during Eric's cross-examination, her carefully constructed facade crumbled. "Ms. Winters," Eric began, "the HOA covenant section you cited when confiscating Judge Mitchell's crutches prohibits storage of equipment in visually accessible areas. Is that correct?" "Yes," Deborah replied stiffly. "Would you please explain how actively used medical equipment qualifies as stored?" "Visual consistency is critical too." "Please answer the specific question," Catherine interjected. "How does equipment in active use meet the definition of stored under your regulations?" Deborah shifted uncomfortably. "We interpret storage to include any visible presence of equipment that affects neighborhood aesthetics." "And who makes that interpretation?" Eric continued. "The board, primarily myself as president." "Have you received any training in federal housing law, particularly regarding disability accommodations?" "Our attorney handles legal compliance." "Yet you personally decided to enter a resident's home and remove medical equipment without legal consultation. Is that standard HOA procedure?" Deborah glanced at Parker, who looked pained. "I was enforcing covenant provisions." "Even if that enforcement caused physical harm," Eric pressed. "I did not intend," Deborah began. "Ms. Winters," Catherine interrupted with judicial authority, "please address the question asked. Were you aware that removing the medical equipment could potentially cause harm?" Under the direct gaze of the woman she had injured, Deborah's composure finally broke. "Property values were at risk," she said, her voice rising. "Special accommodations destroy neighborhood aesthetics. If we make exceptions for everyone with supposed needs, soon we have ramps and railings and medical equipment visible everywhere." Her outburst hung in the courtroom silence. Parker closed his eyes briefly, recognizing the admission for the disaster it was. "Let the record reflect," Catherine stated calmly, "that the witness has characterized accessibility accommodations for disabled residents as aesthetic concerns rather than legal obligations." As the hearing continued, the HOA's case disintegrated further. Financial records revealed selective enforcement and questionable allocation of collected fines. Documentation showed systematic denial of reasonable accommodation, requests without legal consideration of disability laws. In her closing statement, Catherine addressed both parties with measured professionalism. This court recognizes the legitimate purpose of homeowners associations in maintaining community standards. However, no covenant agreement supersedes federal and state laws, particularly those protecting civil rights and reasonable accommodations for disabilities. This case will be decided on legal merits, applicable statutes, and documented evidence. I will issue my ruling tomorrow morning. As court adjourned, Deborah remained seated, staring blankly ahead as the implications of her actions fully registered. Parker gathered his documents, his expression suggesting he was already composing explanations to his law firm about why he had failed to properly review case materials before proceeding. Outside the courtroom, our coalition gathered quietly. No celebration yet. We had witnessed Catherine's scrupulous professionalism and knew she would rule based on law rather than personal vindication. Still, the evidence presented left little doubt about the legal merits of our position. "She was remarkably fair," Eric commented as we walked toward the parking lot. "Most judges would have recused themselves given the personal connection, but she handled it perfectly, acknowledging the conflict but demonstrating she could rule impartially." "That is who she is," I replied. "Even when personally wronged, she believes in proper process. That is what makes this victory meaningful, not personal revenge, but proper application of the law." That evening, Catherine and I avoided discussing the case directly. Judicial ethics prevented her from sharing her thoughts before issuing her ruling. Instead, we shared a quiet dinner, both understanding that regardless of tomorrow's specific outcome, justice was finally being served through proper legal channels. The courtroom was even more crowded the following morning. Word had spread about the remarkable conflict at the heart of the case, drawing curious observers beyond just Willow Creek residents. Catherine entered precisely on time, her black judicial robes flowing as she took her place at the bench, setting her cane carefully aside. "This court is prepared to issue its ruling in Willow Creek Estates HOA versus Thompson et al.," she began. "After careful review of all evidence and applicable law, I find the following." For the next 30 minutes, Catherine delivered a comprehensive ruling that addressed each legal issue with meticulous precision. She acknowledged the legal standing of HOA covenants while establishing their subordination to federal and state housing protections. She cited specific precedents regarding reasonable accommodations for disabilities, selective enforcement concerns, and proper procedural requirements for rule modifications. "The evidence presented demonstrates a clear pattern of discriminatory practices," she stated. "Multiple residents with documented disabilities or medical needs were systematically denied reasonable accommodations, despite federal law requiring such considerations. Furthermore, financial records indicate selective enforcement practices that cannot be justified by legitimate community interests." She turned to specific remedies. "This court hereby orders the following. First, all fines assessed against defendants in this case are invalidated, and any collected funds must be returned with interest. Second, The HOA must establish written procedures for reasonable accommodation requests that comply with federal accessibility laws, subject to court approval. Third, the current HOA board is enjoined from taking any enforcement actions until completing mandatory training in fair housing laws. Catherine paused, looking directly at the HOA representatives. Additionally, the court finds that certain actions taken by HOA leadership crossed from civil violations into potential criminal behavior. Specifically, the unauthorized entry into a resident's home and removal of necessary medical equipment, resulting in physical injury. Her voice remained even, giving no indication she was describing an incident involving herself. The court is referring these matters to the district attorney's office for appropriate review. Finally, she addressed the leadership issue. Given the documented pattern of discriminatory practices under current management, this court orders that new HOA board elections be held within 60 days, supervised by an independent third party. Until such elections, a court-appointed administrator will oversee necessary association functions. She looked up from her notes. To be absolutely clear, homeowners associations serve legitimate purposes in maintaining community standards, but they must operate within the boundaries of federal and state law, particularly regarding disability accommodations, fair housing practices, and protection of individual rights. This ruling aims to restore proper balance between community interests and legal obligations. With a decisive tap of her gavel, Catherine concluded the proceedings. This court retains jurisdiction to ensure compliance with all aspects of this order. We are adjourned. As spectators filed out, Deborah sat motionless, the full weight of consequences finally settling upon her. Parker was already on his phone, likely explaining to his firm how their client's actions had led to such a comprehensive defeat. The remaining board members distanced themselves from Deborah, physically and conversationally, already positioning themselves for the aftermath. Outside the courthouse, Eric addressed our gathered coalition. This is a landmark ruling for HOA oversight. Judge Mitchell established clear boundaries on covenant enforcement while affirming the legitimate role of well-run associations. This will help homeowners throughout the district. The following weeks brought remarkable changes to Willow Creek Estates. The court-appointed administrator, a retired property manager with fair housing expertise, reviewed all existing rules and enforcement procedures. Deborah resigned from the board entirely, listing her house for sale shortly thereafter. Criminal charges were indeed filed regarding the Crutches incident, resulting in community service and mandatory counseling rather than jail time. An outcome Catherine privately told me she considered appropriate given the circumstances. When new board elections were held 2 months later, Jacob Thompson became president, running on a platform of balanced enforcement and inclusivity. Lisa Garcia joined as secretary, bringing her technology background to improve community communications. The new board's first official act was establishing a Reasonable Accommodations Committee, specifically focused on ensuring residents with disabilities or medical needs received proper consideration. With the lawsuit resolved, Catherine's recovery accelerated without the stress of ongoing conflict. 6 months after the court ruling, she was walking with only occasional use of a cane, mainly for longer distances or challenging terrain. Our front porch now featured both a ramp and steps, providing options for all visitors regardless of mobility needs. Most surprisingly, the neighborhood itself transformed. Once freed from oppressive enforcement, residents began interacting more openly. Front yard conversations became common. Children played more visibly. A community garden emerged on previously unused common space. The rigid conformity that had characterized Willow Creek estates gave way to thoughtful personalization within reasonable boundaries. 1 year after the courthouse revelation, we hosted a neighborhood gathering in our backyard, an event that would have triggered multiple violations under the previous regime. Nearly 60 neighbors attended, including many who had been too intimidated to join our initial coalition. As the evening progressed, Catherine and I found ourselves on our porch swing, the very modification that had triggered Deborah's first visit. Jacob Thompson raised his glass in a toast to Catherine and Michael, who reminded us that sometimes justice requires patience, documentation, and following proper channels. Catherine smiled, squeezing my hand. And to community, she added, not the false version built on rigid conformity and fear, but the real kind based on mutual respect and accommodation of differences. As twilight settled over our transformed neighborhood, I reflected on how our ordeal had ultimately strengthened both our marriage and our community. Catherine's professional integrity had never wavered despite personal injury and insult. Her commitment to proper legal process, even when personally wronged, had produced justice more meaningful than any revenge could have achieved. The HOA still existed, still maintained reasonable standards, but now operated with transparency and respect for individual needs. The neighborhood looked different, more diverse in appearance with appropriate accommodations visible. But property values had actually increased as Willow Creek gained reputation as an inclusive, well-managed community. As neighbors chatted on our lawn into the evening, children played tag between yards without fear of violations, and residents with various accessibility needs navigated our property with ease. I realized we had achieved something far more valuable than merely winning a legal battle. We had created the community we had originally hoped to join, one where differences were accommodated, where rules served people rather than controlling them, and where the true measure of neighborhood quality was not visual conformity, but how it supported the actual lives of its residents. The swing creaked gently as Catherine leaned against my shoulder, both of us watching our transformed community with quiet satisfaction. Sometimes justice arrives not as a thunderbolt but as a carefully constructed case, built piece by piece, until truth becomes undeniable. And sometimes the most powerful form of revenge is not destruction of your opponent, but transformation of the system that allowed their abuse in the first place.